Please subscribe, like and share this video. Thank you for your support.
To U.S. Code Chapter 24, Congressional Accountability. To U.S. Code Subchapter 4, Administrative and Judicial Dispute Resolution Procedures. To U.S. Code Paragraph 1401, Procedure for Consideration of Alleged Violations. A. Filing and review of claims except as otherwise provided. The procedure for consideration of an alleged violation of Part A of Subchapter 2 consists of 1. The filing of a claim by the covered employee alleging the violation, as provided in Section 1402 of this title. 2. The preliminary review of the claim, to be conducted by a hearing officer as provided in Section 1402A of this title. 3. Mediation as provided in Section 1403 of this title, if requested and agreed to by the parties under that section. And 4. A formal hearing as provided in Section 1405 of this title, subject to board review as provided in Section 1406 of this title, and judicial review in the United States Court of Appeals for the Federal Circuit as provided in Section 1407 of this title. B. Right of employee to file civil action. 1. Civil action only. A covered employee who has filed a claim timely as provided in Section 1402 of this title and who has not submitted a request for a hearing on the claim pursuant to Section 1405A of this title may, during the period described in paragraph 3, file a civil action in a district court of the United States with respect to the violation alleged in the claim, as provided in Section 1408 of this title. 2. Effect of filing civil action notwithstanding paragraph 2, 3, or 4 of subsection A, if the covered employee files such a civil action. A. The preliminary review of the claim by the hearing officer as provided in Section 1402A of this title shall terminate upon the filing of the action by the covered employee, and B. The procedure for consideration of the alleged violation shall not include any further review of the claim by the hearing officer as provided in Section 1402A of this title. 3. Period for filing civil action. The period described in this paragraph with respect to a claim is the 70-day period which begins on the date the covered employee files the claim under Section 1402 of this title. 4. Special rule for employees who fail to state a claim for which relief may be granted notwithstanding paragraph 3, if a covered employee receives a written notice from the hearing officer under Section 1402A D2 of this title that the employee has the right to file a civil action with respect to the claim in accordance with Section 1408 of this title, the covered employee may file the civil action not later than 90 days after receiving such written notice. C. Special rule for Architect of the Capitol and Capitol Police. In the case of an employee of the Office of the Architect of the Capitol or of the Capitol Police, the office, after receiving a claim filed under Section 1402 of this title, may recommend that the employee use the grievance procedures of the Architect of the Capitol or the Capitol Police for resolution of the employee's grievance for a specific period of time. Any deadline in this chapter relating to a claim for which the employee is using the grievance procedures that has not already passed by the first day of that specific period shall be stayed during that specific period. D. Election of remedies for Library of Congress. 1. Definitions in this subsection. A. Direct Act. The term direct act means an act other than this act or provision of the revised statutes that is specified in Section 1311, 1312, or 1313 of this title. B. Direct provision. The term direct provision means a provision, including the definitional provision of a direct act that applies the rights or protections of a direct act, including rights and protections relating to non-retaliation or non-coercion, to a library claimant. C. Library claimant. The term library claimant means, with respect to a direct provision, an employee of the Library of Congress who is covered by the direct provision. 2. Election. After proceedings initially brought under this chapter, a library claimant who initially files a claim for an alleged violation as provided in Section 1402 of this title may, at any time before the date that is 10 days after a hearing officer submits the report on the preliminary review of the claim under Section 1402A C of this title, elect to bring the claim for a proceeding before the corresponding federal agency under the corresponding direct provision, instead of continuing with the procedures applicable to the claim under this subchapter or filing a civil action in accordance with Section 1408 of this title. 3. Election. After proceedings initially brought under other civil rights or labor law, a library claimant who initially brings a claim, complaint, or charge under a direct provision for a proceeding before a federal agency may, prior to requesting a hearing under the agency's procedures, elect to A. Continue with the agency's procedures and preserve the option, if any, to bring any civil action relating to the claim, complaint, or charge that is available to the library claimant, or B. File a claim with the office under Section 1402 of this title and continue with the corresponding procedures of this title available and applicable to a covered employee. 4. Timing. A library claimant who meets the initial deadline under Section 1402D of this title for filing a claim under this subchapter, or any initial deadline for bringing a claim, complaint, or charge under the applicable direct provision, and then elects to change to alternative procedures as described in paragraph 2 or 3b, shall be considered to meet any initial deadline for the alternative procedures. 5. Application. This subsection shall take effect and shall apply as described in Section 153C of the Legislative Branch Appropriations Act, 2018, Public Law 115-141, except to the extent such section applies to any violation of Section 1331 of this title or a provision of an act specified in Section 1331 of this title. E. Rights of parties to retain private counsel. Nothing in this chapter may be construed to limit the authority of any individual, including a covered employee, the head of an employing office, or an individual who is alleged to have committed personally an act which consists of a violation of Part A of Subchapter 2, to retain counsel to protect the interests of the individual at any point during any of the procedures provided under this title for the consideration of an alleged violation of Part A of Subchapter 2, including as provided under Section 1415d8 of this title with respect to individuals subject to a reimbursement requirement of Section 1415d of this title. F. Standards for assertions made by parties. Any party in any of the procedures provided under this subchapter, as well as any counsel or other person representing a party in any of such procedures, shall have an obligation to ensure that, to the best of the party's knowledge, information, and belief, as formed after an inquiry which is reasonable under the circumstances, each of the following is correct. 1. No pleading, written motion, or other paper is presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of resolution of the matter. 2. The claims, defenses, and other legal contentions the party advocates are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. 3. The factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after reasonable opportunity for further review or discovery. 4. The denials of factual contentions are warranted on the evidence or, if specifically so identified, are reasonably based on belief or lack of information. G. Procedure. Nothing in this chapter shall be construed to supersede or limit Section 1361d2 of this title. 2 U.S. Code Paragraph 1402. Initiation of procedures. A. Claim. 1. Filing of claim. To commence a proceeding under this subchapter, a covered employee alleging a violation of law made applicable under Part A of Subchapter 2 shall file a claim with the office. The office shall not accept a claim which is filed after the deadline applicable under subsection D. 2. Contents of claim. The claim filed under this section shall be made in writing under oath or affirmation, shall describe the facts that form the basis of the claim and the violation that is being alleged, shall identify the employing office alleged to have committed the violation or in which the violation is alleged to have occurred, and shall be in such form as the office requires. 3. No effect on ability of covered employee to seek information from office or pursue relief. Nothing in paragraph 2, or subsection B or C, may be construed to limit the ability of a covered employee, A. to contact the office or any other appropriate office prior to filing a claim under this section to seek information regarding the employee's rights under this chapter and the procedures available under this chapter, B. in the case of a covered employee of an employing office of the House of Representatives or Senate, to refer information regarding an alleged violation of Part A of Subchapter 2 to the Committee on Ethics of the House of Representatives or the Select Committee on Ethics of the Senate, as the case may be, or C. to file a civil action in accordance with Section 1401b of this title. B. Initial processing of claim. 1. Intake and recording. Notification to employing office upon the filing of a claim by a covered employee under subsection A. The office shall take such steps as may be necessary for the initial intake and recording of the claim, including providing each party with all relevant information with respect to the rights of the party under this chapter, and shall transmit immediately a copy of the claim to the head of the employing office and the designated representative of that office. 2. Special notification requirements for claims based on acts by members of Congress. A. In general, in the case of a claim alleging a violation described in subparagraph B, which consists of a violation described in Section 1415d1a of this title by an individual, upon the filing of the claim under subsection A, the office shall notify immediately such individual of the claim, the possibility that the individual may be required to reimburse the account described in Section 1415a of this title for the reimbursable portion of any award or settlement in connection with the claim, and the right of the individual under Section 1415d8 of this title to intervene in any mediation, hearing, or civil action under this subchapter with respect to the claim. B. Violations described. A violation described in this subparagraph is I. Harassment that is unlawful under Section 1311a or 1316a of this title, or 2. Intimidation, reprisal, or discrimination that is unlawful under Section 1317 of this title and is taken against a covered employee because of a claim alleging a violation described in Clause I. C. Use of secure electronic reporting and tracking system. 1. Establishment and operation of secure system. The office shall establish and operate a secure electronic reporting system through which a covered employee may initiate a proceeding under this subchapter, and which will keep an electronic record of the date and time at which the proceeding is initiated and will track all subsequent actions or proceedings occurring with respect to the proceeding under this subchapter. 2. Accessibility to all parties. The system shall be accessible to all parties to such actions or proceedings, but only until the completion of such actions or proceedings. 3. Assessment of effectiveness of procedures. The office shall use the information contained in the system to make regular assessments of the effectiveness of the procedures under this subchapter in providing for the timely resolution of claims, and shall submit semi-annual reports on such assessments each year to the Committee on House Administration of the House of Representatives and the Committee on Rules and Administration of the Senate. D. Deadline. A covered employee may not file a claim under this section with respect to an allegation of a violation of law after the expiration of the 180-day period which begins on the date of the alleged violation. 2 U.S. Code Paragraph 1402A. Preliminary Review of Claims. A preliminary review by hearing officer. 1. Appointment not later than 7 days after transmission to the employing office of a claim pursuant to Section 1402B of this title, the Executive Director shall appoint a hearing officer to conduct a preliminary review of the claim. 2. Process for appointment. The Executive Director shall appoint a hearing officer under this subsection in the same manner and in accordance with the same requirements and procedures applicable to the appointment of a hearing officer under Section 1405C of this title. B. Assessments required in conducting a preliminary review of a claim under this section. The hearing officer shall assess each of the following. 1. Whether the claimant is a covered employee authorized to obtain relief relating to the claim under this subchapter. 2. Whether the office which is the subject of the claim is an employing office under this chapter. 3. Whether the individual filing the claim has met the applicable deadlines for filing the claim under this subchapter. 4. The identification of factual and legal issues involved with respect to the claim. 5. The specific relief sought by the individual. 6. Whether, on the basis of the assessments made under paragraphs 1 through 5, the individual filing the claim is a covered employee who has stated a claim for which, if the allegations contained in the claim are true, relief may be granted under this subchapter. 7. The potential for the settlement of the claim without a formal hearing as provided under Section 1405 of this title or a civil action as provided under Section 1408 of this title. C. Report on review. 1. Report not later than 30 days after a claim is filed under Section 1402 of this title. The hearing officer shall submit to the individual filing the claim in the office which is the subject of the claim a report on the preliminary review conducted under this section, and shall include in the report the hearing officer's determination as to whether the individual is a covered employee who has stated a claim for which relief may be granted under this subchapter, as described in paragraph 6 of subsection B. The submission of the report shall conclude the preliminary review. 2. Extension of deadline. A hearing officer may, upon notice to the individual filing the claim and the employing office which is the subject of the claim, use an additional period of not to exceed 30 days to conclude the preliminary review. D. Effective determination of failure to state claim for which relief may be granted if the hearing officer's report on the preliminary review of a claim under subsection C includes the determination that the individual filing the claim is not a covered employee or has not stated a claim for which relief may be granted under this subchapter. 1. The individual, including an individual who is a library claimant, as defined in Section 1401d1 of this title, may not obtain a formal hearing with respect to the claim as provided under Section 1405 of this title, and 2. The hearing officer shall provide the individual and the Executive Director with a written notice that the individual may file a civil action with respect to the claim in accordance with Section 1408 of this title. E. Transmission of report on preliminary review of certain claims to Congressional Ethics Committees in the case of a hearing officer's report under subsection C on the preliminary review of a claim alleging a violation described in Section 1415d1a of this title. The hearing officer shall transmit the report to 1. The Committee on Ethics of the House of Representatives, in the case of such an act by a member of the House of Representatives, including a delegate or resident commissioner to the Congress, or 2. The Select Committee on Ethics of the Senate, in the case of such an act by a senator. 2 U.S. Code Paragraph 1403, Mediation. A. Availability of mediation. 1. Notification regarding mediation. A. Covered employee. Upon receipt of a claim under Section 1402 of this title, the office shall notify the covered employee who filed the claim about the process for mediation under the section and the deadlines applicable to such mediation. B. Employing office. Upon transmission to the employing office of the claim pursuant to Section 1402b of this title, the office shall notify the employing office about the process for mediation under the section and the deadlines applicable to such mediation. 2. Initiation. A. In general, during the period described in subparagraph B, either the covered employee who filed a claim under Section 1402 of this title or the employing office named in the claim may file a request for mediation with the office, which shall promptly notify the other party. If the other party agrees to the request, the office shall promptly assign a mediator to the claim and conduct mediation under this section. B. Timing. A covered employee or an employing office may file a request for mediation under subparagraph A during the period beginning on the date that the covered employee or employing office, respectively, receives a notification under paragraph 1 regarding a claim under section 1402 of this title and ending on the date on which a hearing officer issues a written decision relating to the claim under section 1405G of this title, or the covered employee files a civil action with respect to the claim in accordance with section 1408 of this title, as applicable. 3. Failure to request or accept mediation to have no effect on treatment of claim. The failure of a party to request mediation under this section with respect to a claim, or the failure of a party to agree to a request for mediation under this section, may not be taken into consideration under any procedure under this title with respect to the claim, including a preliminary review under section 1402A of this title, a formal hearing under section 1405 of this title, or a civil action under section 1408 of this title. B. Process mediation under this section, 1. May include the office, the covered employee, the employing office, and one or more individuals appointed by the executive director from the master list developed and maintained under subsection E, and 2. Shall involve meetings with the parties during which, at the request of any of the parties shall be separated, for the purpose of resolving the dispute between the covered employee and the employing office. C. Mediation period. The mediation period shall be 30 days, beginning on the first day after the second party agrees to the request for the mediation. The mediation period may be extended for one additional period of 30 days at the joint request of the covered employee and employing office. Any deadline in this chapter relating to a claim for which mediation has been agreed to in this section, that has not already passed by the first day of the mediation period, shall be stayed during the mediation period. The office shall notify in writing the covered employee and the employing office when the mediation period has ended. D. Independence of mediation process. No individual, who is appointed by the executive director to mediate, may conduct or aid in a hearing conducted under section 1405 of this title with respect to the same matter, or shall be subject to subpoena or any other compulsory process with respect to the same matter. E. Master list of mediators. 1. Development and maintenance of master list. The executive director shall develop and maintain a master list of individuals who are experienced in adjudicating, arbitrating, or mediating the kinds of personnel and other matters for which mediation may be held under this section. Such list may include, but not be limited to, members of the Bar of a State or the District of Columbia and retired judges of the United States Courts. 2. Consideration of candidates. In developing the master list under this subsection, the executive director shall consider candidates recommended by the Federal Mediation and Conciliation Service or the Administrative Conference of the United States. 2 U.S. Code paragraph 1405, hearing. A. Requirement for hearings to commence in office. 1. Hearing required upon request if, not later than 10 days after a hearing officer submits the report on the preliminary review of a claim under section 1402A C of this title, a covered employee submits a request to the executive director for a hearing under this section. The executive director shall appoint an independent hearing officer pursuant to subsection C to consider the claim and render a decision, and a hearing shall be commenced in the office. 2. Exceptions. Paragraph 1 does not apply with respect to the claim if a. The hearing officer's report on the preliminary review of the claim under section 1402A C of this title includes the determination that the individual filing the claim is not a covered employee who has stated a claim for which relief may be granted under this title, as described in section 1402A D of this title, or b. The covered employee files a civil action as provided in section 1408 of this title with respect to the claim. B. Dismissal. A hearing officer may dismiss any claim that the hearing officer finds to be frivolous or that fails to state a claim upon which relief may be granted. C. Hearing officer 1. Appointment. Upon the filing of a request for a hearing under subsection A, the executive director shall appoint an independent hearing officer to consider the request for a hearing under subsection A and render a decision. No member of the House of Representatives, senator, officer of either the House of Representatives or the Senate, head of an employing office, member of the board, or covered employee may be appointed to be a hearing officer. The executive director shall select hearing officers on a rotational or random basis from the list developed under paragraph 2. Nothing in this section shall prevent the appointment of hearing officers as full-time employees of the office or the selection of hearing officers on the basis of specialized expertise needed for particular matters. 2. Lists. The executive director shall develop master lists, composed of a. Members of the Bar of a State or the District of Columbia and retired judges of the United States Courts who are experienced in adjudicating or arbitrating the kinds of personnel and other matters for which hearings may be held under this chapter, and b. Individuals expert in technical matters relating to accessibility and usability by persons with disabilities or technical matters relating to occupational safety and health. In developing lists, the executive director shall consider candidates recommended by the Federal Mediation and Conciliation Service or the Administrative Conference of the United States. 3. Prohibiting hearing officer conducting preliminary review from conducting hearing. The executive director may not appoint a hearing officer to conduct a hearing under this section with respect to a claim if the hearing officer conducted the preliminary review with respect to the claim under section 1402A of this title. D. Hearing. Unless a claim is dismissed before a hearing shall be 1. Conducted in closed session on the record by the hearing officer. 2. Commenced no later than 90 days after the executive director receives the covered employee's request for the hearing under subsection A, except that, upon mutual agreement of the parties or for good cause, the office shall extend the time for commencing a hearing for not more than an additional 30 days, and 3. Conducted, except as specifically provided in this chapter and to the greatest extent practicable, in accordance with the principles and procedures set forth in sections 554 through 557 of Title V. E. Discovery. Reasonable pre-hearing discovery may be permitted at the discretion of the hearing officer. F. Subpoenas. 1. In general, at the request of a party, a hearing officer may issue subpoenas for the attendance of witnesses and for the production of correspondence, books, papers, documents, and other records. The attendance of witnesses and the production of records may be required from any place within the United States. Subpoenas shall be served in the manner provided under Rule 45B of the Federal Rules of Civil Procedure. 2. Objections. If a person refuses, on the basis of relevance, privilege, or other objection, to testify in response to a question or to produce records in connection with a proceeding before a hearing officer, the hearing officer shall rule on the objection. At the request of the witness or any party, the hearing officer shall, or on the hearing officer's own initiative, the hearing officer may refer the ruling to the board for review. 3. Enforcement. A. In general, if a person fails to comply with a subpoena, the board may authorize the general counsel to apply, in the name of the office, to an appropriate United States District Court for an order requiring that person to appear before the hearing officer to give testimony or produce records. The application may be made within the judicial district where the hearing is conducted or where that person is found, resides, or transacts business. Any failure to obey a lawful order of the district court issued pursuant to this section may be held by such court to be a civil contempt thereof. B. Service of process in an action or contempt proceeding pursuant to subparagraph A may be served in any judicial district in which the person refusing or failing to comply, or threatening to refuse or not to comply, resides, transacts business, or may be found, and subpoenas for witnesses who are required to attend such proceedings may run into any other district. G. Decision. The hearing officer shall issue a written decision as expeditiously as possible, but in no case more than 90 days after the conclusion of the hearing. The written decision shall be transmitted by the office to the parties. The decision shall state the issues raised in the claim, describe the evidence in the record, contain findings of fact and conclusions of law, contain a determination of whether a violation has occurred, and order such remedies as are appropriate pursuant to Subchapter 2. The decision shall be entered in the records of the office. If a decision is not appealed under Section 1406 of this title to the board, the decision shall be considered the final decision of the office. H. Precedence. A hearing officer who conducts a hearing under this section shall be guided by judicial decisions under the laws made applicable by Section 1302 of this title and by board decisions under this chapter.